Welcome to today's video. We're exploring a critical and often misunderstood moment in employment-based immigration. When your priority date becomes current, but your sponsoring employer says the job isn't available. We'll examine the legal core requirement, the consular processing risks, how verification really works, and practical steps to protect your case. We'll also include quizzes to test your understanding, and finish with key takeaways. Here is our roadmap. First, we define the prospective nature of EB visas. Next, we address the timing and evidence needed at consular processing. Then, we uncover verification practices that can make or break your case. After that, we'll outline best next steps, clarify portability, and visualize the decision flow with diagrams. Finally, we'll test your knowledge with short quizzes. Employment-based immigrant visas are prospective. That means the offered position in the approved I-140 must still be available when the immigrant visa is issued and when you seek admission to the United States. If the job no longer exists, or is not currently available, even with an approved I-140, the basis for the visa collapses. Therefore, contemporaneous confirmation of the job is essential at the final stage. Let's walk through the process. When your priority date becomes current, you become eligible to proceed, but that does not assure approval. You typically submit the DS-260 and fees, and your interview is scheduled. At the interview, the consular officer will assess your case based on current facts, including whether there is a current, signed job offer letter confirming the employer's intent to hire you upon entry. A stale or old letter is not sufficient. If the job is unavailable, the officer can place the case in 221G for additional evidence or deny the visa. Consequently, it is safer to align your consular processing and interview timing with a confirmed, current job offer, which requires proactive communication with your employer. Before we proceed, a brief disclaimer. This content is for general educational purposes and does not constitute legal advice. Immigration laws and policies evolve, and consular practices can vary by post and by case. You should seek advice from a licensed immigration attorney who can evaluate your specific circumstances. Consular processing carries a verification risk. Officers are trained to confirm that the offered position still exists at the time of the interview. They may ask for a current offer letter and, where appropriate, contact the employer directly. If the employer reports that the job is not available, the officer is required to refuse or deny the case because the underlying basis no longer exists. Attempting to proceed despite knowing the job is unavailable can trigger findings of misrepresentation, which carry serious consequences. Cases based on older I-140 approvals often receive closer scrutiny and demands for updated evidence. Therefore, a newly dated, detailed employer letter is critical. This mind map organizes your decision points. At the center is the EB visa decision. One branch emphasizes communication. Contact the employer immediately, secure a current signed letter, and confirm the start date is contingent on visa issuance. Another branch suggests delaying if the job is uncertain. Monitor the visa bulletin, and avoid scheduling or attending an interview without a firm letter. A third branch covers proceeding. Do so only when the letter is ready, and prepare updated qualifications and financial evidence. The risks branch reminds you of potential 221G, or denial if there is no job, and of misrepresentation risks if you proceed while aware the job is unavailable. Finally, the alternatives branch contrasts adjustment of status with consular processing, notes AC-21 portability is generally available only when the I-485 has been pending at least 180 days, and explains that joining a new employer may require a fresh perm and I-140. Here are your action steps. First, contact your employer frankly and quickly. Second, request a newly dated, signed offer letter that confirms the employer's intent to hire you when you enter. Third, if the employer cannot confirm availability, delay consular processing rather than risking a denial. Fourth, continue tracking the visa bulletin and keep your documentation ready. Fifth, assemble updated evidence of your qualifications and of the employer's viability. Sixth, speak with an immigration attorney to tailor the plan. Finally, proceed to the interview only after the offer is confirmed and your evidence is current. Let's compare delaying and proceeding. Delaying is best when the employer cannot confirm the job. It reduces the risk of denial and avoids potential misrepresentation concerns while preserving your eligibility and letting you refresh documents. Proceeding is appropriate only when you have a current, signed offer letter. In that case, bring contemporaneous evidence, anticipate employer verification, and benefit from a potentially faster resolution. Clarifying portability is essential. Under INA 204J, portability generally requires that an I-485 adjustment application has been pending for at least 180 days. In consular processing, there is no pending I-485, so portability is usually not available. Therefore, the original sponsor's job offer must remain active through visa issuance and admission. If the sponsor revokes the offer before you become eligible to port in an adjustment of status context, your case is at risk. If the job disappears, your alternatives may involve starting a new perm, an I-140 with a new employer, or exploring whether you qualify to switch to adjustment of status to utilize portability. Quiz time. The question asks, which document must be current and newly dated to confirm eligibility at the interview? Option 1 is a newly dated official job offer letter from the sponsoring employer. Option 2 is the original I-140 petition and old offer letter. Option 3 is a generic letter from any employer. Option 4 is future pay stubs. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is the newly dated, official job offer letter from the sponsoring employer. Consular officers verify current facts and require contemporaneous confirmation of the job. Here is the second quiz. Your priority date is current, but the employer states the role is not available. What is the safest strategy? Option 1 is to rush to schedule the interview. Option 2 is to delay consular processing and obtain written reaffirmation when the job becomes available. Option 3 is to attend the interview and hope the officer overlooks it. Option 4 is to switch employers mid-consular processing and claim portability without an I-485. You may pause the video now to consider your answer. We will discuss the correct choice in the next section. The correct answer is to delay consular processing and obtain written reaffirmation from the employer when the job is available. This approach minimizes the risk of refusal or denial and avoids potential misrepresentation issues. These are the key points. Employment-based visas are prospective, so the job must exist at the time of issuance and entry. A current, signed offer letter is essential. If the job is unavailable, delaying consular processing is safer than risking a denial. Officers may directly contact the employer to confirm availability. Portability generally requires a pending I-485 for at least 180 days and is not usually available in consular processing. Consult a qualified attorney for tailored advice. In summary, a current priority date affords eligibility to apply, but it does not by itself secure the visa. A current and confirmed job offer is what enables issuance, time consular processing, to coincide with a reaffirmed offer. When uncertain, pause, communicate with your employer, and plan with legal counsel. Thank you for watching. If you found this helpful, please like, share, and subscribe. Share your scenario in the comments so we can address it in future videos.